Thank you, Judge. Before you this morning are two cases, the first of which is 26 CR 837, captioned State of Ohio versus Stephen W. Lowry. Judge, on August 3rd of 2026, the state filed an information. Contained in that information were two counts. The first count was aggravated possession of drugs, a felony of the third degree in violation of ORC 292511. Attached to that charge was a forfeiture specification of those drugs. The second count was a charge of tampering with records, a felony of the third degree in violation of ORC 2913.42. It's a felony of the third degree because the records involved here were that of a governmental agency, that being the Wickliffe Police Department. The second case, Judge, is 26 CR 839, once again captioned State of Ohio versus Stephen W. Lowry. And once again, an information was filed in this case as well on August 3rd of 2026. The information contains two counts. Those charges are count one, a possession of heroin, a felony of the fifth degree in violation of ORC 292511 with the attached forfeiture specifications for the drugs. And the second count being a charge of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination thereof, a misdemeanor of the first degree in violation of ORC 4511-19A1A. The defendant is present today in court with counsel, Mr. Kerr. It is the state's understanding that he is desirous in both cases of waiving his right to have his case proceed to the grand jury and plead guilty by way of information in both of those files. Should those pleas be forthcoming upon inquiry by the court, it is the state's further understanding the defense intends to ask for pre-sentence investigation in both cases, and at this time the state and the defense do not have a joint agreement as to sentence, but the state would join in the request for a pre-sentence investigation to review the defendant's background.
Thank you. 1 second. This OVI is recent, I'm assuming, right?
The OVI is from 23, Judge.
2023?
Yes.
Also before the law changed?
Yes, because I put the fines from the 2023 code book in there. I believe.
Why is it so old?
He was at large.
Okay. Okay. Yeah, this would have been in effect April of 25, so that's right.
I believe the fine or the suspension is the same, the 1 to 3 years, but the fine changed.
Okay, that's still it's 1 to 3 years now, at least.
Yeah, I Xeroxed my book.
Okay.
I don't even know if that's a correct term anymore. I copied.
Sorry?
I don't even know if Xerox is the right term or if it's old school.
The only thing I changed on the case without the OVI, 837 case, you have that it's a mandatory fine of $5,000 to $10,000. Then on page 3 you say maximum fine is $20,000, $10,000 mandatory.
Well,
It's only $5,000 that would be mandatory.
oh, okay. I'm sorry.
So I changed that. It's $5,000 to $10,000, so it's got to be done, but the minimum's $5,000. All right, so Mr. Kerr, were you able to hear what the prosecutor had to say regarding what she believes the defendant's intentions are here today, and what summary of your discussions you had with her?
Yes, Your Honor, that is all accurate.
Mr. Lau, were you able to hear what was said by the prosecutor here?
Yes, Your Honor.
She indicated that she believes it's your desire in both of these cases to waive your right to have these cases presented to a grand jury, and I'll explain in a moment what that means in more detail. And then you're going to plead guilty to the charges that are set forth in each information, which I will also review with you to make sure you understand them. We would then continue the sentencing today, get some evaluations completed, come back on a future day for sentencing, where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right, well, let's get started then. How old are you, sir?
38.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, have you received a copy of the two informations that were filed in each of these cases? That's the document that sets forth what the charges are?
Yes.
Had a chance to look those over?
Yeah.
I'll start with the lower case here, 26 CR 837. In that case, you're charged with 2 counts, and this is what you're going to be pleading guilty to and admitting to. First off, in count 1, it's alleged that on or about June 19th, 2026, in Willowick Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or a compound mixture, preparation, or substance containing methamphetamine. It's a Schedule II controlled substance. The amount involved was more than the bulk amount, but less than 5 times the bulk amount. It was 3.38 grams, which makes the offense aggravated possession of drugs a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, Your Honor.
Any questions about it?
No, sir.
Now, the charge also carries with it a forfeiture specification that alleges during the commission of the offense you possessed or had an interest in property considered to be contraband. Contraband is property that's illegal to possess just by the nature of the property itself. And here it's the methamphetamine. Now, this forfeiture specification doesn't increase any potential penalty you face, but you forfeit any ownership interest you have in it. It allows the state to properly dispose of it at the end of the case. Do you understand that?
Yes.
Any questions?
No, sir.
Now, in count 2, what's alleged here is on or about June 19th, 2026, in Willowick Lake County, Ohio, that you, knowing that you had no privilege to do so, with purposes of fraud or knowing you were facilitating a fraud, falsified, destroyed, removed, concealed, altered, defaced, or mutilated a writing, computer, software, data, or record. And the writing, data, software, or record that was involved in this case is kept or belongs to a local, state, or federal governmental entity by the Willowick Police Department specifically, which makes the offense tampering with records a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 2 of this case?
Yes.
Any questions about it?
No, sir.
Now, in case 26 CR 839, you're also charged with 2 counts. Count 1 alleges on or about May 10th, 2023, in Wickliffe Lake County, Ohio, that you did knowingly obtain, possess, or use heroin or some compound mixture, preparation, or substance containing heroin. The amount did not exceed 1 gram. It was 0.17 grams, which makes the offense possession of heroin a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1 of this case?
Yes, Your Honor.
This case also carries with it a similar forfeiture specification that I explained, but the contraband in this case is the heroin. You understand that?
Yes.
Any questions about that?
No.
Now, in count 2, what's alleged and what you're admitting to is on or about that same day, May 10th, 2023, in Wickliffe, Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. That offense constitutes the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's a misdemeanor of the 1st degree. Do you understand what you're charged with and pleading guilty to in count 2 of this information?
Yes.
Any questions for me?
No, sir.
Well, then, before I can accept your guilty plea to the charges in each of these cases, I need to make sure you understand all the rights you're giving up. And these rights I'm going to review with you apply to both cases. I'm not going to go over them twice. They apply in both cases. If there's something that applies to one case and not the other, I'll make sure I let you know that. But otherwise, everything I'm going over with you applies to both cases, all right?
Okay.
And in each of these cases, you're charged by way of an information. An information is a criminal charge or charges that are brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Now, everybody in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward in the charges brought by the prosecutor and the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession here a document, one for each case, called a waiver of indictment. And those documents set forth what I just explained to you about the grand jury process, and that you want to give up that right. Again, before I can go any further, I need to be assured you understand these documents and that you sign them here in open court. Now, my understanding is before I walked out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes.
Mr. Kerr, is that accurate? Did you review the waiver of indictment with your client, read it over with him, answer all his questions?
I did, Your Honor.
Did he indicate an understanding of it to you?
Yes, he
Is
did.
that correct, Mr. Lowry?
Yes, sir.
So you went through it and you understand what it says?
Yes.
Any questions for me about them?
No.
It also appears you signed them. Did you sign them?
I did, Your Honor.
And Mr. Kerr, you witnessed those signatures?
I did, Your
And
Honor.
Ms. Naroda, you as well?
Yes, sir.
Very well, the court will make those documents part of the record in each respective case. At this point, Mr. Lowry, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you first of all have a right to a trial in each of these cases. There'll be two separate trials. And that could be to me as a judge, where I listen to the evidence and I make the decision whether you're guilty or not guilty. But you also have a constitutional right in each case to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. Unanimous means that all 12 jurors would have to agree together, one way or the other, as to each individual charge, guilty or not guilty. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to have a trial in both of these cases?
Yeah.
Now, if we did have a trial, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the state of Ohio here be represented by the prosecutor, and she would have what we call the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since these are criminal charges, that burden of proof is what we refer to as proof beyond a reasonable doubt. Highest burden of proof we have in our justice system. What it means, it's the amount of the evidence and the quality of all that evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges at a trial. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, in order to do that, or at least in order to try to do that, if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to, within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not obligated to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would ultimately have to make. Do you understand that?
Yes.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, in 26 CR 837, pleading guilty to 2 felonies of the 3rd degree. Each of these are punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So if I decide a prison term is warranted, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36. For each count, it could be the same, could be different, but that'd be the number of months in prison you'd have to serve for that particular count. Do you understand that?
Yes, sir.
Now, since there's 2 separate charges here, if I do impose a prison term on each of the counts, I have the discretion as the judge to run those prison terms either concurrent or consecutive to each other. Concurrent means together at the same time, whereas consecutive means one after the other. You'd serve the prison term on the first count, finish it, complete it in its entirety, then serve the prison term on the next count. Do you understand that?
Yes, Your Honor.
Now, in the other case, 26 CR 839, you have charged with 2 counts. One of them is a felony. The felony charge is the heroin charge. It's in the felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
Now, count 2 is the OVI. It's a misdemeanor of the 1st degree. This offense is punishable by a possible, isn't there a minimum jail sentence on this? At least 3 days?
3 days, yes.
Yeah.
Which can be served in a tri-rated, well, it doesn't matter.
In this case, yeah. So for the OVI charge, you can be sentenced, you have to be sentenced to at least 3 consecutive days in jail, but you can be sentenced up to 6 months or 180 days in jail. Do you understand that?
Yes, Your Honor.
Now that's jail, that's not prison, it'd be jail. You understand that?
Yes.
If a prison term is imposed on the heroin charge, any jail sentence imposed on the OVI by law has to be served concurrent with a prison term, meaning at the same time again. I do not have the discretion to run a jail sentence on a misdemeanor consecutive to a prison sentence. You understand that?
Yes.
So the maximum prison sentence you face in this case is 12 months for the heroin charge. You understand that?
Yes, Your Honor.
Now there are 2 separate cases here, and if I do impose a prison term in each case, I do have the discretion to run those prison terms consecutive to each other for each case. Do you understand that?
Yes.
So in the first case, you're facing up to 6 years in prison. Second case is 1 year in prison. So altogether, there's a maximum possible prison term that can be imposed at sentencing of 7 years in prison. Do you understand that?
Yes.
Are you currently on probation or parole to any other courts or agencies?
No, sir.
Do you have any other charges pending against you anywhere?
No, I do not.
If a prison term is imposed in either of these cases, upon your release from prison, you could be placed on what's called post-release control. I sometimes call that parole or PRC. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, could be up to 2 years for for either case. The maximum is 2 years. Do you understand that?
Yes, Your Honor.
And if you were put on post-release control in any of these cases and never violated any of the rules of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes.
Now, aside from the possible prison term, there are other sanctions that could be imposed. In 26 CR 837, the OVI charge carries with it a mandatory, strike that. In 837, it's the drug charge and the tampering with records. The drug charge carries with it a mandatory fine of at least $5,000, and it could be fined up to $10,000. Do you understand that?
Yes.
The tampering with records carries with it a possible fine of up to $10,000. You understand that?
Yes.
So in this particular case, there'll be a fine imposed of at least $5,000, but you could be fined up to $20,000. Do you understand that?
Yes.
Now, in the other case with the OVI and the heroin charge carries with it a possible fine of $2,500. The OVI charge carries with it a fine maximum of $1,075, but at least a mandatory fine of at least $375 that has to be imposed. You understand that?
Yes, Your Honor.
So in this case, there'll be a fine of anywhere between $375 and $3,575 that's imposed. Do you understand that?
Yes.
In each case, you could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes, Your Honor.
In each case, you also forfeit, as I mentioned before, any ownership interest you have in the contraband that was listed in the specifications. Do you understand that?
Yes.
Lastly, these charges carry with it, in 26 CR 837, that's the drug charge, the methamphetamine charge, and tampering with records. The drug charge carries with it a possible license suspension of up to 5 years. Do you understand that?
Yes.
In the other case, 26 CR 839, the drug charge carries with it a possible suspension of up to 5 years. The OVI charge carries with it a mandatory license suspension of at least 1 year up to possibly 3 years. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison term you face with these charges. I used the word possible because Prison is not mandatory in either of these cases. In each case, you are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't automatically mean you get probation? It means that I consider it, if that's what you're asking for. I'll look at all the information presented, then I'll make the decision in each case that I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control sanctions, and well, let's strike that. Let me back up for 1 second. While the charges in each of these cases are all probationable, I do need to advise you that in 26 CR 837, that's the case with the methamphetamine and the tampering with records, the drug charge of the methamphetamine does carry with it what's called a presumption for prison, meaning the court has to impose a prison sentence unless certain findings can be made at the time of sentencing, which would allow the court, me, as a judge, to overcome that presumption and put you on community control sanctions. Do you understand that?
Yes, Your Honor.
Now, if you were put on community control sanctions in either of these cases, as the judge, first of all, it could be up to 5 years of supervision, and as the judge, I would have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that?
Yes.
Further, if you ever are on probation to this court and you violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. And if I determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I can impose more restrictive sanctions against you, including an order that you serve time in jail, or I could terminate your probation at that point and send you to prison then. And if I did it at that point, again, it could be for the period of time that I mentioned before, which the maximum with both cases combined was 7 years. Do you understand that?
Yes, Your Honor.
And that can also be consecutive to any other prison term you could be serving for another case somewhere else, or that you're being sentenced to at that time for something new. Do you understand that?
Yes.
Lastly, when we do proceed to the sentencing hearing, you'll have the right on that day, say anything you want, anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
You understand that whatever the lawyers have to say at the time of sentencing, really whatever anyone has to say regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I'm not obligated to go along and follow those if I don't think it's the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding the potential penalties you face in either of these cases by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your lawyer, have him review all the reports with you, answer all your questions?
Yeah,
Are you satisfied with his advice and counsel?
I am.
Has he or anyone else for that matter made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty here today?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering a guilty plea freely and voluntarily?
Yes, Your Honor.
All right, well, do you have any questions for me then regarding anything we just talked about? What you're pleading guilty to, the rights you have that you give up by pleading guilty, penalties you face, any questions at all?
No, sir.
Do you need any more time to talk to your lawyer before we go forward with the actual plea?
No, sir.
All right, then what we're going to do at this time, the prosecutor here is going to explain for me what she believes the evidence in this case would, in both of these cases, would show if we did have a trial. I want you to listen to her because then I'll have some follow-up questions for you. So we'll do one case at a time. We'll start with the earlier one, the 23 case, and then we'll move on. So, Ms. Naroda, if you can, I think that case is the 26 CR 837 case. So if you can.
It's the 839 case.
Sorry?
I believe it's the 839.
What did I say?
837. You want to start with the lower case number or the earlier?
I want to start with the earlier case. Oh, yeah, it's the OVI, that's 839.
Yeah.
Yes, thank
That's
you.
the case you want me to start
Yes.
with? Okay. All right. Judge, with respect to that case, that being 26 CR 839, had the state proceeded to trial, the state would have brought forth the following facts that support the charges the court has previously outlined, and that was this: that on May 10th of 2023, the defendant was operating a motor vehicle, and he was found to be asleep at the wheel at the East 305 State Route 2 exit ramp. The light had cycled through and turned green, and as a result of various calls, the Wickliffe Police Department responded and found him slumped over, asleep at the wheel. The officer was able to rouse him and wake him. He was slow to move, had very slurred speech, constricted pupils, and very droopy eyelids. They invited the defendant out of the car, and he failed all field sobriety tests that were administered at that time. He was taken into custody and arrested for operating a motor vehicle under the influence of alcohol, a drug, or a combination thereof. And when he was patted down, he was found to have a cigarette pack in his pocket, and contained in that packet was a folded piece of paper with what appeared to be a controlled substance. That substance was forwarded to the Lake County Crime Lab and determined to be heroin, a Schedule I controlled substance, weighing in at 0.17 grams. The defendant initially appeared in court and then failed to appear thereafter for subsequent hearings, and a warrant was issued. And he was at large until his arrest and custody in the case that gave rise to 26 CR 837. And that was on June.
All right, hang on, let's do that. So you're moving on to the next one now?
Yes.
All right,
Yes.
let's stop for a second.
Okay.
Mr. Lauer, are you able to hear what the prosecutor had to say regarding what she believes the facts would show in 26 CR 839? That's the case involving the possession of heroin in the OVI.
Yes.
And what, if anything, did it say about those facts as she presented them? Are they true? Did you do what she said?
Yeah, that was all true.
Sorry?
Yes, sir. Everything was true.
Very well then. As to count one, charging you with possession of heroin, a felony of the 5th degree, what is your plea to that count with the forfeiture specification?
My plea, Your Honor? Guilty.
As to count two, the operating vehicle under the influence of alcohol, drug abuse, or a combination of them, a misdemeanor of the 1st degree, what is your plea to that?
Guilty.
All right. We'll now move on to 26 CR 837. Mr. Naroda?
Thank you, Judge. Had the state proceeded to trial, the following facts would have been brought forth, and that was on June 19th of 2026. Willowick Officer Patrolman Baker conducted a traffic stop of a vehicle. The defendant was the front seat passenger. Prior to going out on patrol that day, Officer Baker had checked the local warrants that had been issued by his agency as well as neighboring agencies, and reviewed those warrants to be on the lookout for those individuals as well as photographs of those individuals. So upon conducting the traffic stop of the vehicle for a moving violation, when he approached the vehicle, he recognized the defendant as Stephen Lowry with an outstanding warrant for the case that we have previously just discussed in the passenger seat. When he approached the vehicle and spoke with the driver of the vehicle, he noticed the defendant had his head down, was looking at music on his phone, and was ignoring the officer. When he eventually did make contact with him, the defendant told him his name was Michael Lowry, and he maintained that he was Michael Lowry throughout the entire proceeding and booking process as well. He was taken into custody as a result of the warrant, and when taken back to the station, and when he was changing clothes, there was the drugs that give rise to count one in the information were found in his boot. And those drugs were forwarded to the Lake County Crime Lab and determined to be methamphetamine, a Schedule I controlled substance weighing 3.38 grams. During that booking process, the defendant maintained that he was Michael Lowry, who I believe to be the defendant's brother, and he signed various documents, including fingerprint cards, as Michael Lowry when asked to sign throughout that process at that time, Judge.
Thank you. Mr. Lauer, are you able to hear what the prosecutor had to say regarding what she believes the evidence would show in 26 CR 837?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she presented them to the court? Are they true? Did you do what she said?
Yeah, that's all true.
Very well, then regarding count 1, charging with aggravated possession of drugs, a felony of the 3rd degree, that drugs being methamphetamine, a Schedule II controlled substance, along with the forfeiture specification, what is your plea to that?
Guilty.
As to count 2, charging with tampering with records, also a felony of the 3rd degree, what is your plea to that?
Guilty.
All right, I have in my possession at this time 2 other documents, both of them, they're the same, except there's one for each particular case with the respective charges set forth in each. They're each called a written plea of guilty and judgment entry, which set forth everything we've just talked about. Before I can accept your guilty plea in either of these cases, I need to make sure you understand what these documents say, and you sign them here in open court. Now, my understanding is that in regards to each of these documents, you had a chance to previously review them with your lawyer before I walked out here. Is that right?
Yes.
Again, Mr. Kerr, did you review these with Mr. Lowry, read them over with him, answer all his questions?
I did, Your Honor.
Did he indicate an understanding of these documents to you when you did that?
Yes, he did.
Is that correct, Mr. Lowry?
Yes, Your Honor.
So you understand what these say?
Yes.
Do you have any questions for me at all regarding what these documents and the contents of these documents indicate?
No, sir.
It also appears on each of these that you signed them both. Did you sign them?
Yes.
You witnessed that, Mr. Kerr?
I did.
You too, Ms. Naroda?
I did, Judge.
Very well, then, at this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. And in case 26 CR 837, I'll find the defendant guilty of count 1, aggravated possession of drugs, a felony of the 3rd degree, violation of 292511 of the revised code, the forfeiture specification, as well as count 2, tampering with records, also a felony of the 3rd degree, in violation of 2913.42A1. As the case 26 CR 839, I'll accept the defendant's pleas of guilty, find the defendant guilty of count 1. Possession of heroin, a felony of the 5th degree, violation of 292511 of the revised code, the forfeiture specification, and count 2, operating a vehicle in influence of alcohol, a drug of abuse, or a combination of them, that being a misdemeanor of the 1st degree in violation of 4511-19A1A. I'll defer sentencing, order pre-sentence report investigation, drug and alcohol evaluation for each case. 26 CR 837, bond will be continued at $50,000 cash surety, and bond will remain revoked in 26 CR 839. Ms. Naroda, is there anything else for the record at this time?
Nothing further, Judge.
Mr. Kerr?
Your Honor, could you clarify again, what did you say about in terms of the evaluation that you were ordering?
A pre-sentence report
Okay.
and a drug and alcohol
Oh,
evaluation.
okay, I didn't hear that.
Anything else you want?
That's all.
Any other type of report?
No, that is sufficient, Your Honor.
Okay.
Thank you.
All right, thank you all.
All rise.